Hello! I'm back with part 5 of the Alaska State Constitution. My name is Amanda and I am Gen X Alaska, starting my little timer. Alright, so we're starting with Article 6, Legislative Apportionment. Okay. House districts. Members of the House of Representatives shall be elected by the qualified voters of the respective House districts. The boundaries of the House districts shall be set under this article following the official reporting of each decennial census of the United States, amended 1998. Decennial. I think that's every 10 years. I think. Senate districts. Maybe it's every 20 years. 10? I don't know. Senate districts. Members of the Senate shall be elected by the qualified voters of the respective Senate districts. The boundaries of the Senate districts shall be set under this article following the official reporting of each decennial census of the United States, amended 1998. Reapportionment of House and Senate. The redistricting board shall reapportion the House of Representatives and the Senate immediately following the official reporting of each decennial census of the United States. Reapportionment shall be based upon the population within each House and Senate district as reported by the official decennial census of the United States, amended 1998. Method of redistricting. The redistricting board shall establish 40 House districts, with each House district to elect one member of the House of Representatives. The board shall establish 20 Senate districts, each composed of 2 House districts, with each Senate district to elect one senator, amended 1998. Combining districts, repealed by 1998 ballot measure number 3. District boundaries. The redistricting board shall establish the size and area of House districts, subject to the limitations of this article. Each House district shall be formed of contiguous and compact territory containing as nearly as practical and relatively integrated socioeconomic area. Each shall contain a population as near as practicable to the quotient obtained by dividing the population by the state by 40. Each Senate district shall be composed as near as practicable of 2 contiguous House districts. Consideration may be given to local government boundaries. Drainage and other geographic features shall be used in describing boundaries wherever possible. Modification of Senate districts, repealed by 1998 ballot measure number 3. Redistricting board. A. There shall be a redistricting board. It shall consist of 5 members, all of whom shall be residents of the state for at least 1 year, and none of whom may be public employees or officials at the time of or during the tenure of appointment. Appointments shall be made with that regard to political affiliation. Board members shall be compensated. B. Members of the redistricting board shall be appointed in the year in which an official decennial census of the United States is taken and by September 1 of that year. The governor shall appoint 2 members of the board. The presiding officer of the Senate, the presiding officer of the House of Representatives, and the Chief Justice of the Supreme Court shall each appoint 1 member of the board. The appointments to the board shall be made in the order listed in this subsection. At least 1 board member shall be a resident of each judicial district that existed on January 1st, 1999. Board members serve until a final plan for redistricting and proclamation of redistricting has been adopted and all challenges to it brought under Section 11 of this article have been resolved after final remand or affirmation. C. A person who was a member of the redistricting board at any time during the process leading to a final adoption of a redistricting plan under Section 10 of this article may not be a candidate for the legislature in the general election following the adoption of the final redistricting plan, amended 1998. Board actions. The board shall elect one of its members, chairman, and may employ temporary assistants. Concurrence of 3 members of the redistricting board is required for actions of the board, but a lesser number may conduct hearings. The board shall employ or contract for services of independent legal counsel, amended 1998. Redistricting plan and proclamation. A. Within 30 days after the official reporting of the decennial census of the United States, or 30 days after being duly appointed, whichever occurs last, the board shall adopt one or more proposed redistricting plans. The board shall hold public hearings on the proposed plan, or, if no single proposed plan is agreed on all plans proposed by the board, no later than 90 days after the board has been appointed and the official reporting of the decennial census of the United States. The board shall adopt a final redistricting plan and issue a proclamation of redistricting. The final plan shall set out boundaries of House and Senate districts and shall be effective for the election of members of the legislature until after the official reporting of the next decennial census of the United States. B. Adoption of a final redistricting plan shall require the affirmative votes of 3 members of the redistricting board, amended 1998. Enforcement. Any qualified voter may apply to the Superior Court to compel the redistricting board by mandamus, that's a new word, mandamus, or otherwise to perform its duties under this article or to correct any error in redistricting. Application to compel the board to perform must be filed not later than 30 days following the expiration of the 90-day period specified in this article. Application to compel correction of any error in redistricting must be filed within 30 days following the adoption of the final redistricting plan and proclamation by the board. Original jurisdiction in these matters is vested in the Superior Court. On appeal from the Superior Court, the cause shall be reviewed by the Supreme Court on the law and the facts, notwithstanding Section 15 of Article 4. All dispositions by the Supreme Court under this sections, that's a typo, it should say shall be expedited and shall have priority over all matters pending before the respective court. Upon a final judicial decision that a plan is invalid, the matter shall be returned to the board for correction and development of a new plan. If that new plan is declared invalid, the matter may be referred again to the board, amended 1998. Editor's note. The Division of Elections publishes maps and district descriptions resulting from the proclamation of redistricting by the Alaska Redistricting Board, April 25th, 2002. Article 7, Health, Education, and Welfare. Public education. The legislature shall by general law establish and maintain a system of public schools open to all children of the state and may provide for other public educational institutions. Schools and institutions so established shall be free from sectarian control. No money shall be paid from public funds for the direct benefit of any religious or other private educational institution. State University. The University of Alaska is hereby established as the state university and constituted a body corporate. It shall have title to all real and personal property now and hereafter set aside for or conveyed to it. Its property shall be administered and disposed of according to law. Board of Regents. The University of Alaska shall be governed by a Board of Regents. The regents shall be appointed by the governor, subject to confirmation by a majority of the members of the legislature in joint session. The board shall, in accordance with law, formulate policy and appoint the president of the university. He shall be the executive officer of the board. Public health. The legislature shall provide for the promotion and protection of public health. Public welfare. The legislature shall provide for public welfare. Natural resources. Statement of policy. Article 8, natural resources. Statement of policy. It is, and there's a typo, the policy of the state to encourage the settlement of its land and the development of its resources by making them available for maximum use consistent with the public interest. General authority. The legislature shall provide for the utilization, development, and conservation of all natural resources belonging to the state, including land and waters, for the maximum benefit of its people. Common use. Wherever occurring in their natural state, fish, wildlife, and waters are reserved for the people for common use. Sustained yield. Fish, forests, wildlife, grasslands, and all other replenishable resources belonging to the state shall be utilized, deployed, and maintained on the sustained yield principles subject to preferences among beneficial uses. Facilities and improvements. The legislature may provide for facilities, improvements, and services to assure greater utilization, development, reclamation, and settlement of lands, and to assure fuller utilization and development of the fisheries, wildlife, and waters. State public domain. Lands and interests therein, including submerged and tidal lands, that's TIDAL, tidal lands, possessed or acquired by the state and not used or intended exclusively for governmental purposes, constitute the state public domain. The legislature shall provide for the selection of lands granted to the state by the United States and for the administration of the state public domain. Special purpose sites. The legislature may provide for the acquisition of sites, objects, and areas of natural beauty or of historic, cultural, recreational, or scientific value. It may reserve them from the public domain and provide for their administration and preservation for the use, enjoyment, and welfare of the people. And we'll stop right there and continue in part 6 of Amanda, Gen X Alaska, your little nerd who just wants to know everything I can know about Alaska, reading the Constitution of the state of Alaska. And like always, you have to watch me walk off because I don't want to edit. Love ya!